Next case on the docket is FUZZELL versus DuPont.
May it please the Court. I'm Patrice Talisman on behalf of the appellants Frank and Lois FUZZELL and FUZZELL Wholesale Nursery. This is an appeal from a final order dismissing the appellant's case under Florida Rule of Civil Procedure 1.420E for lack of prosecution. We believe the order was erroneous for four separate reasons. First, the lower court applied the wrong version of Rule 1.420E. Second, the court refused to follow the holding of the Supreme Court in Metropolitan Dade County versus Hall. Third, the court entered the dismissal even though the stay order had been entered. And finally, plaintiff showed good cause and the trial court abused its discretion in failing to recognize that. I'd like to address each issue separately and get to them because the first few issues are clearly matters of law. Don't really need a lot of facts to involve them.
Is the controlling issue on the first issue a determination of when the obligation arose to the statute to kick in?
The controlling issue is what is the triggering event for application of the rule. The trial court held that that there had been a change in the time period, and it was the time period, the period during which there was no prosecution, which was in fact the controlling event. But the fourth DCA in Swate, the second DCA recently, just this month, in fact, in Pagan versus Facilla Corp., have both expressly held that where the motion to dismiss, the hearing on the motion, and the order of dismissal were all occurred after the effective date of the amendment to the rule, that it is the amended rule that applies. The third DCA had earlier held in Sabri versus Shantz-Shatton that the rule in effect at the time of the motion to dismiss is the appropriate one. So we now have three district courts saying that in fact it's the motion, the filing of the motion that is the triggering event that determines what is the applicable version of the rule that applies. And it's quite clear.
Go ahead.
If you do an analysis, that's appropriate. I mean, we all know that rules of procedure apply to pending cases. Whether or not an application is retroactive the question is whether or not.
Everybody agrees that this is a prospective
application.
Rule, right?
Yes,
and it should be applied.
And this is a prospective application because you're looking at the triggering event. What is the event?
Does under the old rule, the period of 1 year non-activity expired and then the motion would be filed? Is that correct?
Yes, Your Honor.
All right, so we have a 1 year period under the old rule. Under the new rule, we have a 10-month period plus a 60-day period in order to cure the non-activity and to file something.
Which becomes exactly the very same period as the fourth DCA held in Swate.
Here's my question to you, and I think that was one of the factors that they pointed to, but my question to you is, under the new rule, the 10-month period expires, then the motion must be filed and the plaintiff must be served. And then after the plaintiff, or after the non-active party, we'll put it that way, after the non-active party is served, the non-active party will then have 60 days in order to cure the non-activity. So if we include the period of service, say for example the service wasn't made for 15 or 30 days, doesn't that necessarily extend the 1 year period?
It could, but you could also hand deliver the service.
You could do that.
You could hand deliver the notice, and therefore that would be, and in fact, even if it's mailed, you would only get 5 days. I don't think there would ever be in a period. But if you hand delivered it, as you have a right to do under the rules, you would have exactly the 1 year period.
What if you hand delivered it 15 or 20 days later? If you file the 10-month period goes by, the motion is filed, then the non-active party must be served. And let's assume that that they hand delivered it or served the non-active party 15 or 20 days later, and then the non-active party would have 6 months. Doesn't that necessarily extend the time limit?
Not really, Your Honor, because I mean, even with the motion to dismiss for lack of prosecution, You could have waited 18 months and filed it. That didn't mean that you extended the
But the
period for
the 1 year
prosecution
period,
for
the
18
1 year period had necessarily expired by that time, though. You have to wait for the 1 year period.
You went back 1 year from, usually went back 1 year from the date of the filing of the motion. And in this case, you would go back 10 months from the date of the filing of the notice. And then you would have 2 months, 60 days after that. So you would still have exactly 1 year. So I don't think that the period does change.
The first question is, isn't it true that 10 months plus 60 days could be less than, equal to, or greater than 1 year, depending on which 2 months are involved? If it's February and March, that's 28 and 31, that's only 59. If it's March and April, it's 61, right?
Theoretically, it could be, but every time I counted it, I got exactly the same day coming up.
Well, maybe you didn't deal with February, which is a short one.
Well, I mean,
my second question becomes, does it make any difference?
I don't think it does, because what you're really dealing with isn't, did we change the period by 1 day? Did we change it by 2 days or 15 days? But what is the effect of the motion? Because
I don't know that it makes any difference either, but I think in some of the cases that you were referring to, it was a factor that, well, the 10 months plus the 60 days equals 1 year, and so that it didn't really change, and so it's the same thing anyway. And
Swate said this is the same period. The 4th DCA in Swate did in fact hold this is the same period of time. Depends on how you want to look at the period, because it could be extended by the time of service, and it couldn't be. As I said, it could have been extended.
Bottom line is, your argument is common sense tells you that it's the date you file the motion that's the triggering date, right?
Yes, because just like with the speedy trial rule, here you aren't entitled to a dismissal for lack of prosecution until you file the motion. Under the old rule, once you filed the motion, you just looked backwards, and if you hadn't done record activity, you didn't show good cause, it was automatically dismissed. Under the new rule, you look back 10 months, but you're not automatically entitled to dismissal. Instead, you have a window period where record activity can occur. If record activity occurs within the next 60 days, then in fact dismissal is inappropriate. That was exactly the instance in Zabrani versus Cowart, which was approved by the Florida Supreme Court in Bloom versus McKnight. It was a speedy trial rule. Originally, the speedy trial rule, defendant filed a motion for discharge. If in fact the speedy trial rule had run, he was entitled to immediate discharge. Amend the rule, you file the motion, no longer entitled to immediate discharge, but instead to a window period. The state had a window now in which they could try the defendant.
Let me ask you this. If the key issue is what's the triggering event, I don't know that I understand why, whether the time period changed or not, is relevant to that, because it's what rules in effect at the time of the triggering event. So I have trouble with the concept of what difference does it make if the time frame changed. But in light of that, how do you deal with the workers' comp case, which apparently said changing from 1 year to 2 years or vice versa made a difference? Is that bad law? Is it distinguishable? What's your position?
It's distinguishable. In first place, in Blue versus Malone, what the court actually did was it looked to when the cause of action was filed, not when the period of lack of prosecution began, because the 1 year period for lack of prosecution didn't start, or the period for lack of prosecution didn't start running until after the rule change had already occurred. So the court didn't say that it's when the period of lack of prosecution begins that is the triggering event. It went back and looked at when was the cause of action filed. And I think that the court did that because it was under the workers' comp rules. And under the workers' comp rules, the Florida Supreme Court has said we only had power to make the workers' comp rules because the statute, as part of the substantive powers of worker comp, gave it to us. We weren't dealing with it as a rule of procedure under constitutional, Article 5, Section 3, but instead it's because of statutory powers. So first of all, Blue said it was when the cause of action was filed. That clearly is not the triggering fact, so I think it was badly decided, other than to say this was a substantive right of the cause of action. We're now dealing with procedure. It's quite clear that procedure applies to rules of procedure. Amendments to them apply to pending cases. Blue, from the first DCA, can't change the decision of the Florida Supreme Court that approved the analysis in Bloom, which said that the triggering event, when you have a motion, when it's a motion that entitles you to a discharge and instead you get a window, the triggering event is the motion. Not when the cause of action was filed, not even when the period of the speedy trial, or in this case, the lack of prosecution began, but when the motion is filed. So I think Blue is wrong. The other case they relied on was NatCow. And NatCow is entirely different because there you have, do you apply an amendment to the rules of civil procedure to a case that's over and final? It wasn't a question of when did the period begin. It was a question of, in NatCow, the final judgment itself, which rendered the case over and done with, was over by had been entered prior to the amendment to 1.540. So the Florida Supreme Court was essentially saying, yeah, we apply rules of procedure to pending cases. This isn't a pending case. We're not going to go back and apply this rule to this judgment that is final. So, in fact, I think those cases are totally
in this
distinguishable.
particular case, say, for example, we say that the new rule applied and that the 60-day grace period applied. Was there something filed within that 60 days that would satisfy that? And
yes, Your Honor. There were two things. First, there was an order of the court. And the second DCA in Pagan, we just filed a no supplemental authority because it was just decided, said for the 60-day period you apply the very same bright line test that the Supreme Court announced in Wilson versus Solomon. Either there's record activity or there's not record activity. Court order is obviously record activity. Second,
what was the court order you're referring to?
It's just order of recusal. It was entered about 6 days after the motion to dismiss for lack of prosecution. Thereafter, plaintiffs filed a motion to lift stay and to set a case management conference. It was filed, the 60 days ran on a weekend. It was filed on that Monday. So it was filed on what under Rule 1.090 would be the 60th day.
So that motion was timely filed?
That motion was timely.
With the weekend rule? Okay.
Because this court itself has held, I think it was Carter, that 1.090 calculation applies to 1.420. And the rule itself says that.
So a motion, an order of recusal is sufficient to...
Bright line test. Is there record activity?
I mean, there are
Wilson
cases,
versus Solomon.
There are cases,
that was the Supreme Court. So in fact, there was record activity.
Oh.
So under 1.420E, as amended, it's quite clear that the order of dismissal should be reversed. In addition, as we pointed out, there's the language in second issue. The language in Metropolitan-Dade County versus Hall, the Florida Supreme Court expressly held in that case that for the purpose of the application of Rule 1.420E, depositions and offers of judgment are to be treated as if they had been filed in the record, except that where there is no record activity for a year, the depositions and offers of judgment taken during that year must be brought to the court's attention in writing at least 5 days before a hearing on a motion for dismissal based on Rule 1.420E. Offers of judgment are to be treated as record activity as long as they are filed beforehand, 5 days in advance of the hearing on the motion to dismiss for lack of prosecution. Defendant in this case had made offers of judgment. It's quite clear under the prior rule, under this rule, if you're dealing with record activity by any party is sufficient to satisfy the requirements of the rule. Florida Supreme Court said it has to be treated as record activity, therefore defendant's offers of judgment are sufficient to preclude dismissal under Metropolitan-Dade County versus Hall. In addition, there was an order, the lower court had entered an order staying all discovery until further order of court. The prior version of Rule 1.420E expressly provided that dismissal shall not be granted if a stay order has been entered.
What's the language of the old rule about stays?
Yes.
What kind of stays are we talking about?
There was never any language in the rule as to what kind of stay. There has been case law that says if the stay is within the control of the parties, but in this case, the order expressly said that it will be stayed until further order of the court, not until plaintiff
the
says
action
X,
wasn't
Y, or
stayed,
Z.
was it?
I'm sorry.
The action was not stayed, was it?
It was a
wasn't
stay of discovery and filing of witness lists
So
and things
you
such
could
as
do
that.
anything you want in the case short of discovery.
There was nothing else to do, Your Honor, other than discover. I mean, you're
How
in
about
that
filing
pre-trial
amended
period.
pleadings?
The motion for leave to amend was already filed. It was a question of filing the proffer, and that leads to the fourth point. The showing
Before you move on, what was the language of the old rule related to stay?
the language of the old rule was that dismissal is inappropriate if a stay order is filed. If there's been a stipulation of the action or a stay order is filed. That was the exact language of the rule. I have it here. Hold on.
Well, it says, or a stay order has been filed or a party shows good cause. So
Right,
you have to
right.
file a stay order
Yes.
of some sort.
Unless a stipulation stating the action is approved by the court or a stay order has been filed or a party shows good cause in writing at least 5 days. That was the prior version of the rule. And I'm sorry to be rushing. I wanted to be able to save some time for rebuttal, and I wanted to be able to at least address the good cause issue. This court recognized Martin versus Putnam County that both calamity and disability equal good cause that will prevent dismissal of an action for lack of prosecution.
We have an abuse of discretion standard on that.
Yes, Your Honor, you do.
Correct?
This is the only point that the abuse of discretion standard applies to, but I admit that it does in fact. Here, it is clear that what happened was in November of 2004, the defendant had produced 70 CDs of documents, 4 million documents, without a searchable index, without an index that was useful in terms of searching it. You were talking about I could have filed my proffer for the punitive damages. In order to do that, I needed to go through, or plaintiff's counsel needed to go through those 4 million documents. And since the
Wasn't there
index,
some evidence in the record that some representation was made that you were ready to do that, or you had sufficient
no, Your Honor, that we had
evidence to do
started the review, and that what we could tell so far was that it was not complete. In fact, their cover letter with the 70 CDs said, the point was that at the first hearing they said, we'll give you all the documents in the depository. Then the cover letter comes over and says, well, we're giving you all the documents in the depository except for the Crawford files, except for the electronic media, except for this. So what counsel said was, look, I've done a cursory review essentially, and I can tell that I don't have everything. He could tell that just by looking at the cover letter. He never said that it was complete. And in fact, before he got the documents, he said, look, it all depends on whether or not there is an appropriate searchable index to it and whether or not I can, in fact, search the documents online, or I'm going to have to do it page by page. And what it turned out he had to do was page by page. So from November of 2004, when he got the documents, until October of 2005, he had in fact gone through 1 million pages of documents, page by page. He had printed out, collated, annotated, organized 250,000 documents. Hurricane Wilma comes through, blew through his office, blew out the glass walls. As Mr. Ratiner described it, I was left with an empty shell of an office and 17 garbage bags of wet documents. It took him 3 months to get his office up and running. In that period of time, and the court recognized that. And the court recognized that he had a very limited practice. I think he filed 6 pleadings. He noticed there was a deposition noticed and then canceled because it couldn't be done. There were some notices simply to file notices. There was no real work being done or capable of being done in that 3-month period because of the destruction of the office from the
How long after that 3-month period was the motion?
6 months. But the problem was that in order to go back and redo the proffer, he had to go back and restart that work. It was destroyed. It was 17 garbage bags of wet documents. He had to start again with the CDs, culling, going through them page by page, pulling the pages, finding them, and printing them in order to do it. So it's not simply that there is 4 months, it's the need to redo that year's worth of work. And there was no dispute about that in the evidence. The court took evidence, there was nothing contrary to it, there was also an affidavit filed in support that showed this. So you have not simply that he had 6 months available, but that he had to redo the year's worth of work in order to get back to the point where he had been in order to be able to file the proffer. And certainly under the court...
Well, all he would have had to do was, for example, schedule a hearing. Send out a notice of hearing by the end
Your
of the
Honor, there was a
year,
stay
right?
order. There was a stay order.
That prevented him from noticing the motion for the proffer?
He had to do the proffer in order... if you accept... It was plaintiff's position, or it was plaintiff's understanding that the action was stayed until the proffer was done.
And how was the proffer going to be done? You were going to have a hearing on that?
Yeah, you would file it, and then actually the rules say you have to file the proffer, and then you have the hearing 20 days later. You have to give at least 20 days that they review. So he needed to go back through these documents in order to complete the proffer so that that part of the action could go forward, and that was what the court wanted to happen. So that's why it takes the full year. I mean, you have the work being done for 6 months of the year, hurricane coming through and destroying it, or 3 months, or actually from November of 2004, then the hurricane coming through, and it's that year's worth of work that has to be recreated in addition to the physical destruction of the office that leads to the showing of good cause, as well as his surgery and requirement of recuperation from it. I have no time. I would request the court's indulgence for a few moments for rebuttal.
I'll give you 2 minutes for rebuttal and add it to the other side's time as well.
Thank you, Your Honor.
Good morning. May it please the court. I'm Michael Rosen of Shook, Hardy & Bacon, counsel for the appellee DuPont. And joining me at counsel table today is my colleague Bonnie Dayball. I'd like to try to address some of the questions that the court has raised.
Let me ask you this. The
Yes,
trial judge indicated that the critical determination would be when the obligation arose and the rule that was in effect when the obligation arose. Do you agree with that?
I agree that, yes, when the obligation arose, if you take into account the fact that the trial judge, Judge Harris, also pointed out that it was the triggering event and relied on NatCal for that, because that was what gave rise to the obligation to file something within a 1-year period. This was not a situation where...
The obligation doesn't really arise then, does it, till day 364? You don't have an obligation to do anything during the first month after your last activity or your second month. Doesn't the obligation arise on day 364 that you better do something?
The obligation isn't really, under the old rule, an obligation on the plaintiff, Your Honor. That's kind of the irony here. We think under the new rule, the 60-day period is, and that hasn't been determined yet by the Florida Supreme Court. But under the old rule, under the Wilson decision, any record activity would have been sufficient. So what it did was not so much create an obligation directly on the plaintiff as it created a right on the part of the defendant and the court, because remember, and Judge Harris made this distinction too, that under the old rule, and I think under the new rule as well, in fact, I'm sure under the new rule as well, it isn't just the defendant that has a right to file a motion to dismiss for failure to prosecute at the end of that period. The court or any interested person could do it.
And that goes to a point that I'd like to question you about. The rule doesn't even become effective until a motion is filed either under the old rule or the new rule. Isn't that correct? Yet a motion has to be filed by the clerk can do it, the court can do it, or a party can do it, right?
That's correct.
Right. But a motion has to be filed under the old rule or the new rule. Is that correct?
Yes, sir.
Why doesn't it just make common sense to say that the triggering event is the filing of the motion, since the motion triggers the application of the rule to begin with? Because,
as the court found in NatCal, what you cannot do is change the period in the middle of the game. You know, I use a sports analogy. Like in a game of college basketball, the team has 35 seconds after it takes possession to take a shot.
But if the motion is if we say the filing of the motion under the rule is a triggering event, and the triggering event occurs after the new rule has become effective, how does that make the new rule retroactive rather than prospective?
Because it's changing the period in the middle of the period. Suppose it had gone the other way, Your Honor. Suppose they had shortened the period and said you had to file it within 10 months, no interval for notice, no 60-day grace period. Then the plaintiff would be the one complaining, wait a minute, I was supposed to have a full year, and you've cut me off. You've shortened the period. The point is that the rule that's in effect at the time of the triggering event determines the length of the period.
What do you say, what's the triggering event under, what do you say the triggering event?
The last record activity. The last record activity is the triggering event. And that's what the triggering event in NatCal was, the entry of the final judgment, which started the same 1 year period.
NatCal involved a different rule, didn't it?
It involved a different rule, but it was a civil rule. And like this, it involved a 1 year period. It involved an attempt to apply an amendment that took effect after the period started.
If we exclude time for service and you know, the leap years and that sort of thing, essentially when you add the 10 months plus the 60 days, it's essentially a 1 year period, the same as the overrule, isn't it?
Well, that's what the court in Swate held, Your Honor, but what they overlooked, it's wrong because there's a 1 year interval. I'm sorry, at least a minimum of a 1 day interval. Here's the difference. Under the old rule, the clock ran continuously for 365 days, and you looked at the record to see if there was any record activity. Under the new rule, the clock runs continuously for 10 months, then it stops, then you have an interval of at least 1 day to file a motion. Even if you hand deliver it, you've got an interval of at least 1 day, and then the clock starts running again for 60 days. And as Judge Palmer pointed out, there's no way you can add up on a calendar 10 months plus 1 day, if it's just a minimum of 1 day, plus 60 days, and always come out a year. Now, to their credit, counsel for the appellant pointed out in their reply brief that in this particular instance, it would happen to end on the same day. But I pulled out a calendar and went through the exercise of checking it. They filed their notice of non-availability. Well, they served it on March 26th. On May 26th. It was received and docketed by the court on June 3rd, and that was the triggering event that started the 1 year period running. If it had been received and docketed a day earlier on June 2nd, then the 1 year period would not have coincided with the 10 plus 1 plus 60 period. It would have been a day later. And if they had received it and docketed 2 days earlier on June 1st, it would have been 4 days later. So it does change the period. It's true, it's a small change. But I think the principle applies the same. And again, once the period starts, a new rule cannot interfere with it. That's the whole idea of perspective.
How is this case distinguishable from the Pagan case or the Sweet case?
Well, the Swate case is clearly distinguishable because there the defendant filed their motion for dismissal after only 11 months. So they obviously weren't relying on the 1 year rule. They filed their motion after 11 months, so there was record activity after 11 months. So there nobody was contending that the 1 year rule, the prior, that was previously in effect, applied. In Pagan, we don't know. The court clerk issued the notice. The defendant didn't file a motion. And there's no indication that anybody contested it. In fact, in both Swate and Pagan, you'll notice that the appellee made no appearance. So we don't know if the issue was ever presented and litigated and contested. In fact, none of the cases that have been decided in which we had this straddle situation indicate that it was ever contested. In the Edwards case...
Well, what's the holding in the Pagan case?
Well, the holding in the court applied the new rule. We don't dispute that. What we're saying is, can that really be considered controlling precedent if, in fact, it was undisputed? And we don't know that it was disputed. In fact, it appears to have been undisputed. All we're saying here is that, Judge Harris was presented this issue to decide. We don't know if the judge in the Pagan case was ever even presented the issue. The defendant didn't move for dismissal. It was issued by the court clerk. The court just said the new rule applies, but there's no indication, particularly since the appellee made no appearance, that anyone disputed that.
In Swate, the court specifically stated, and I'm quoting, the new rule does not change that the minimum period of inactivity required prior to a motion dismissed for lack of prosecution is 1 year.
Yes, sir.
So they seem to say that it's the same. 10 months plus 60 days is 1 year, and then under the old rule, it's 1 year.
Well, Your Honor, two things. First of all, it's dictum.
Was the court wrong when they said that?
Well, first of all, it's dictum because the issue of whether the old rule applied wasn't even an issue in Swate. The defendant filed their motion after 11 months, so they were relying on the new rule. They weren't even arguing the old rule, and they didn't appear on appeal to argue it. But more importantly, stating that the new rule does not change that the minimum period of inactivity required prior to motion to dismiss for prosecution is 1 year is simply wrong. Well,
Well,
it's true that the minimum period
Excuse
would
me,
be 1 year.
the court in Swait, it seems to me, went through an analysis of the old rule and the new rule, and what's the difference between the two. It seems like they examined it pretty thoroughly and stated in their analysis that the period's the same.
Well, Your Honor,
You're just saying that's just wrong?
I'm saying not only is it wrong because they didn't take into consideration the fact that you have this interval. I mean, first of all, again, physically, 10 months plus 60 days doesn't necessarily equal 1 year. It depends on what months it falls on. It depends on where the weekends fall. So they're not identical. But putting that aside, the court went through that analysis. It's unclear why. Because there is no way possible that the old rule could have applied. It couldn't possibly apply if the defendant filed their motion to dismiss after 11 months. It was a complete dictum. And, of course, dictum shouldn't be relied upon as precedent to overrule what the trial judge did here, where the trial judge undertook a full analysis of the implications.
So your bottom line position is that we have to go back to the last filing that would constitute record activity, and that determines whether the new rule or the old rule should apply.
If the new rule...
Bottom line analysis.
Well, yes, sir. If the new rule takes effect while the clock is running.
Right, yeah, I understand.
Right.
But you're saying basically the triggering date then is not when the motion under the rules filed, it's when we go back and look at the last record activity, whatever that may be, and I'm still not sure I know what that exactly is, but in any event, whatever I guess anything could be filed to show record activity, but that's the determining point, and then you move forward.
Yes, sir.
Okay, all right.
It's whatever the last record activity was. And, of course, that it's interesting that the court, of course, ultimately resolved this in, first resolved it in Metropolitan-Dade County versus Hall, a case that...
I guess anything that's filed is, and it's in the record, is a record activity. I guess it.
Under Wilson, construing the old rule. Now, here's an interesting point, though, and this came up again in a question. If the new rule applied, would the filing of a court order, say, constitute record activity within the 60-day period? That issue hasn't been addressed. Everyone seems to assume that the Wilson rule would apply. And we agree that under the old rule it applies, and in fact, we don't disagree with the outcome of Metropolitan-Dade County versus Hall. In fact, it vindicated dissenting opinions that Judge Griffin had filed in the Nichols and Levine case to say, look, if there was off-record activity, if they were really engaged in discovery, that case shouldn't be dismissed for lack of prosecution. But what Metropolitan-Dade County versus Hall said is, you're right, but that's a good cause analysis. That's not a record activity. If it's not on the face of the record, and that was ultimately confirmed by the Florida Supreme Court in Wilson, when they adopted it, it's a bright-line rule. If there's something on the face of the record, the trial judge can see it, and there's no dismissal for lack of prosecution. If there isn't anything on the face of the record, then you have to go to the second step, which is the good cause analysis. And that's exactly what Judge Harris did in this case. The question that they raise is whether the off-record activity, which was not the plaintiff's activity, but the defendant, DuPont, served, didn't file because the rule doesn't require it, but served an offer of judgment. Now, would an off-record service of an offer of judgment constitute record activity? Absolutely not. And that's not what the court said in Metropolitan-Dade County versus Hall. They used the language that it be treated as, but if you read what the court said in Hall before the sentence they quote, and I have it here, indulge me for just a moment. Here's what the court said, Florida Supreme Court, and this was Justice Wells, and I'm going to come back to that in a second. The court said, in this case, there was no activity on the face of the record as required by Rule 1.420E. This was, the offer of judgment. The issue in this case, therefore, becomes whether the offer of judgment and depositions taken but not filed were activities in the case that were done in good faith and moved the case forward to a conclusion so as to meet the good cause basis for not dismissing the action. So the court ultimately agreed that it made no sense not to take into account off-record activity, although there it was off-record activity by the plaintiff that moved the case forward, not relying on something the defendant did. So they ultimately agreed with that, but in this case, what off-record activity was there by the defendant? None. There was absolutely nothing done off the record by the plaintiffs for the 1 year period, or even during the 60-day period if you don't count the interval. If you actually do what you were suggesting, Judge Sawai, which is put if you can say that putting the 10 months together and the 60 days together, and you ignore the 1 year interval, which is what the court in Swate had to have done, if you put those together and say that equals a year, then you go back and count, and their service was late. The document they filed, which ironically was not the motion, setting a hearing on their motion to amend their pleadings, which the court had told them 3 times, I'm not going to.
Are you referring to the fact they filed the motion the weekend, the Monday after the weekend, and you're claiming that was late?
I'm saying if you count the days under the new rule, I mean, assume for the moment that the new rule applies, which we dispute, of course. Right. But assume for the moment the new rule applies, and there are 2 ways you could count it. We agree that the conventional way of counting it would be to go 10 months, then you stop the clock. You have a day to file, a day or whenever you file, but at least 1 day to file the notice of non-activity for the 10-month period, and then you start the clock again for another 60 days. That's the conventional way of counting it, and if you count it that way, their filing of their motion to lift the stay and to set a case management conference would be timely by coming over the weekend and falling on a Monday. But suppose, if you agree that that's how the period is counted, then it's changed the time period. And if it changes the time period, it's not a prospective application. It's retroactively affecting a clock that has already started running, which is exactly what the court said in NatCal. But if you do, that's what I was saying, if you do take that period and you pull out the 1 day interval, or again, however many days it takes to file the notice, and you just put those together, then, you count the days, and their activity would have had to have been filed on Friday, not on Saturday or Sunday. It's only because you got that 1 day interval.
Does the new rule say that the non-active party has 60 days after service of the motion, or I'm trying to remember what the new rule says. I thought the new rule said it gave them 60 days after service of the motion. Is that right?
It gives them 60 days after the notice is filed. Now, we're talking about motions.
It's the filing date rather than the service on the. How are they supposed to
Your Honor, Judge Swai, it wouldn't matter, because you can't file or serve anything until after the last day of the 10-month period.
Right.
So you're going to have at least this 1 day interval unless you count the day of service. If you count the day of service, then you come closer to doing what the Swate court said, which was say it's still.
Here's the point I'm trying to make.
Okay.
It's the point I made before. I think the new rule says that and no record activity occurs within the 60 days immediately following the service of such notice. So I guess it goes back to the question I asked before. When you include the time for service, you have the day to file the notice, or I call it the motion, right. And then say, for example, service doesn't occur until 15 or 20 days later, then they have the 60 days.
Right.
I guess that would extend the 1 year as well and make it longer than.
Yes, sir. Now, again, we don't dispute that in this case, coincidentally, the 1 year day ends on the same. But the question is whether it changed the application of the rule. And there's no way that you can work it to say that in every case, which is what I think this court has to be concerned with, whether there's a uniform application, that in every case, 1 year of continuous inactivity equals 10 months plus 1 day plus 6 months. And the 1 day, as you say, Your Honor, service, it may extend to a week, a month, however long, but it's not going to be a year. And the question is, can the running of the clock be interrupted? The Florida Supreme Court in NatCal said no. Once it's running, you can't change that period, and NatCal has never been receded from or overruled, and it's more recent in time. And another interesting point, you can look at the policy behind this amendment and say the court wanted to benefit parties who would otherwise be cut off by this deadline. But that was the same thing that was going on in NatCal. They lifted the 1-year limitation on post-judgment relief motions where there was a fraudulent financial affidavit. They wanted to help people like the wife who filed her motion too late. But they had to apply a uniform rule. If it affects something that's already started, a clock that's already running, it's not prospective. It's retroactive.
Is it relevant that NatCal was a closed case at the time the rule was changed?
I don't, Your Honor, if it was a closed case, it seems to me that the new rule would have applied. There wouldn't have been any debate about whether the old rule applied or not, because it would have been a prospective application. So at least for purposes of the court's analysis there, they had to have been treating it as if the running of the 1-year period for a motion for relief from judgment, at least under those circumstances, the case was still pending for that purpose.
If we say for purposes of prospective versus retroactive application of the rule, that it really doesn't matter if the time period was extended 1 day or a few days for service, and we say that that's really not the relevant factor, then what would your argument be about the triggering date being the date that the motion is filed?
Well, first of all, Your Honor, I think the appellants have conceded in their brief that the determining factor under the cases they rely on, Zabrani and Bloom, is whether the amendment would change the time period. So, as a prefatory statement...
I'm just for purposes of argument only.
If you say that changing the time period doesn't affect whether it's applied retrospectively or prospectively, then we agree, then the new rule would apply.
And would the triggering date be the date that the motion would be filed? I mean, wouldn't that make sense? If the date that the motion was filed,
it really wouldn't.
The trigger of the application, if the motion triggers the application of the rule, wouldn't it make sense that the triggering date would be the date that the motion is filed?
If you redefine the triggering date that way, but I mean, then it wouldn't matter when the last record activity was. You're basically redefining the rule. In any event, well, I guess I do have a little bit of time left. I didn't want to overlook talking about good cause because, well, first of all, we think that Judge Harris was absolutely correct. There was no activity on the face of the record here, no matter what rule you apply. And so after 1 year, we were entitled to dismissal, and that couldn't be interrupted. But moving on from that...
Well, you're now through your time plus the extra 2 minutes I gave you.
I'm sorry. I didn't realize I was running. I apologize. We respectfully request that the court affirm the judgment entered below. Thank you very much for indulging me the extra moments, Judge.
I will try to do this very quickly. Let me start with the question of retroactivity. Certainly, as Your Honors pointed out, or as was agreed during the argument, we didn't have an obligation to file a new pleading. I mean, if it's a 1 year under the old rule, then you have to file it on the 365th day. That obviously would have been after the effective date of the new rule.
Now, the motion that you ultimately filed on the 60th day to keep this case alive, which was apparently a motion for a case management conference.
And to allow discovery to lift
Any
the
reason
case.
why that couldn't have been filed at any time during the year before that, in spite of hurricane, in spite of all your other good cause arguments? What's the good cause for not even filing a motion for a case management conference on day 365?
Because there are two arguments. One, we're operating under the new rule, so the rule applies now, so there is no obligation to have done so. And second, the court has said the case has stayed until I get my proffer done. Here I am working on my proffer because I've had to redo everything. So those are the reasons why it wasn't done. If in fact we had thought that the 365-day period still applied, notwithstanding the amendment of the rule, obviously things would have been filed. But we were under the impression, as later established by the courts, Swate in the 4th DCA clearly holds it, and the 2nd DCA has now held in Pagan and expressly that the motion, that once it applies, then that's, once the rule of amendment takes effect, it's the motion. Their right to move for dismissal wouldn't have accrued until there had been 365 days worth of non-activity. That didn't occur until after the effective date of the amendment. The very definition of retroactivity from Tejada versus in re forfeiture, a statute doesn't operate retrospectively merely because it's applied in a case arising from conduct antedating the statute's enactment or upsets expectations based in prior law. Rather, the court must ask whether the new provision attaches new legal consequences to events completed before its enactment. The period of inactivity wasn't completed. In Tejada, it was, do I have a right to contest a forfeiture when I'm not appearing before the court, when I'm absent?
Thank you, counsel. Your time's expired.
Thank you.